This lecture covers temporary alimony. In a separate lecture, I covered alimony in general. This is regarding, again, temporary alimony. Okay, with temporary alimony in Florida, we're also backtracking a little bit to the mandatory disclosure, or otherwise recalled as initial discovery that we're working with the client to achieve. And temporary relief has an abbreviated requirement as far as these documents are concerned, the documents required. So basically it's mandatory discovery. Here, these items: the financial affidavit, Form 12.902B, federal and state personal income tax returns for the past 3 years, the IRS forms, W-2, 1099, and K-1 for the past year, and pay stubs for the past 6 months. This way the court has enough information for a temporary award. However, the final award, as we talked about, requires a lot more documents, a lot more discovery, mandatory discovery having been taken care of. And this is abbreviated more so that the court can get a general idea for temporary support reasons. The time that's required to provide mandatory disclosure is governed by Florida rules of family law practice, Rule 12.285, subsection B1, A, and B. The petitioner has 10 days prior to a hearing, and the respondent has 5 days prior to a hearing. The procedure is like this for maintenance. Again, is what it's called in this. In light of temporary, it falls under the category of maintenance, not alimony per se. So a party that's seeking a divorce may request temporary alimony by filing a motion for temporary relief along with the initial petition for dissolution or thereafter while the case is pending. The need and ability to pay are the primary considerations, just like in the regular alimony lecture I provided. Assessment of need isn't limited to subsistence, but rather refers to a lifestyle comparable to the pre-filing standard. The extent to which the party claiming alimony is capable of self-support is super important, or could be capable if using best efforts, imputed income, is also relevant. Considerations such as the length of the marriage or existence of a prenuptial agreement play no part. Remember, they can't be defended, particularly under situations where we have a disparate income between the parties. And the degree of precision we use is in permanent alimony. That is, that word permanent's used a lot in literature, by the way, but there is no such thing as permanent periodic alimony. But they're referring to alimony, not the kind that's after there's been a decree entered, a dissolution decree entered. So the degree of precision typically required in permanent alimony, which isn't the right word, but it's the best word, in this analysis is not required for temporary alimony determination, since any over or above underpayment can be rectified at the time of the final hearing. There is in Florida a requirement that there be mediation prior to a hearing. They require mandatory mediation for contested issues of temporary alimony and other temporary relief matters. So the parties must attempt mediation before they can schedule a hearing with a judge on these temporary issues. When a hearing is necessary, that would be when mediation fails to produce a full agreement on the temporary alimony issue, and the matter can then proceed to a court for a hearing, and a judge can decide. There are exceptions. The court may waive the mediation requirement in circumstances such as when there's a history of domestic violence. It applies to other issues, like the same requirement to mediate before seeking a court hearing. It also applies to other temporary matters such as child support and child custody. Scheduling a hearing while the mediation is required, the parties aren't forced to reach an agreement. The goal is to facilitate communication and compromise with the help of a neutral, certified mediator before it escalates to the judge. If mediation fails to produce a full agreement on the temporary alimony issue, the matter can then proceed to a court hearing for the judge to decide. You'll use JAX to schedule your hearing, and you'll do a notice of hearing. Modification of pendente lite. Pendente lite means pending litigation. So if you have maintenance, would be pendente lite because it's during litigation. Court-ordered alimony must be modified by court action, not a unilateral decision. A pendente lite or nominal award is not permanent form of alimony award, and the court may increase or decrease pendente lite awards of alimony. And the door is open for changes due to resolution of the case, which is not a modification. The case resolves, like the previous slide indicated, they can handle leftover issues at the final hearing for dissolution, and that seals it. After that point, they become modification opportunities to the final award, if it is a modifiable award. Again, it's Chapter 12, Alimony and Spousal Support from the Florida Bar is an excellent source for people to look at if you want to know more. It's available on Westlaw. If you have Westlaw, if not, maybe a library, your local library can help you with that. Or I know that the courthouses have Westlaw for public use. So if you're a member of the public, you could always go there and do this. Thank you.